In Penal Code Section 187, California defines murder as killing another human being with malice aforethought. Now, malice aforethought is kind of a legal jargon that basically means that you were either trying to kill the other person deliberately, trying to end their life, or that you were acting with a wanton disregard for human life. Now, the typical examples of murder are you shooting somebody, stabbing somebody, hiring a hitman to kill someone, or poisoning a person. But there are also murder cases where somebody could be convicted when he wasn't trying to kill or even harm anybody. To give you an example, suppose you're operating a methamphetamine laboratory in your basement and you have a bunch of explosive chemicals in there. And there is an explosion and your neighbor gets killed. You could be charged with murder because you knew and understood the risks that were involved, but nevertheless went ahead and did the dangerous activity anyhow. Or we see a lot of DUI murder cases, a situation where a person has a prior DUI conviction and sort of knows the dangers of drunk driving, but nevertheless gets heavily intoxicated and drives a car recklessly and causes an accident that kills another person. In that situation, the drunk driver could be charged with murder. And indeed, there are many people in California prison who are serving life sentences for murder arising out of a DUI accident. A conviction for murder in California almost always entails life in prison. Sometimes a person may be eligible for parole at some later date, although it's very difficult in this system if you're convicted of murder to get paroled. So usually if you're convicted of murder, it really is literally a life sentence. And if you have a loved one who's charged with murder, you want to do everything that you can now to fight the case and try to beat the case and avoid having them convicted and sent to prison for life. The good news is here at Shouse Law Group, we've had a great deal of success in fighting murder charges for our clients. And we have assembled an amazing statewide group of attorneys and investigators. These include former prosecutors like myself who used to prosecute murder cases, and former homicide detectives who used to investigate murder cases for the various police agencies, who now work in a defense team to help clients who are charged with murder. And what we found is that when we get a murder case, there's 5 typical defenses that we look at. First of all is self-defense. Even if our client did kill another person, did take another person's life, it may have been in a situation where the other person was the aggressor, the other person was threatening our client, and our client was merely acting in righteous and legitimate self-defense or defense of his family. The second typical defense that we look at in a murder case is mistaken identification. Now, mistaken ID is the #1 reason across California and across the United States why innocent people get convicted. And especially in a situation where, let's say there was a gun involved or a weapon, witnesses to the crime have a tendency to fixate on that weapon and not get a good look at the perpetrator. And especially in a chaotic situation where witnesses are scared and they're under stress, they are particularly prone to misidentifying the suspect in a photo lineup or a live lineup. This happens all the time, and many times we find that we have a client who's innocent because they've been misidentified by witnesses. The third typical defense to a murder charge is that our client was not involved. So maybe he was hanging out with a group of people and one of his friends or associates pulled out a gun and shot a victim and killed the victim, but our client had nothing to do with it. Oftentimes, the police and prosecutors will try to put a case on everybody who was there and say that they are what they call an aider and abettor, or that there was some sort of conspiracy, that our client was in on it and everybody who was there was in on it. But a lot of times, our client was literally a bystander, or a client was merely present and had no intention of participating in a murder and therefore shouldn't be held liable. The fourth typical defense in a murder case is not guilty by reason of insanity. So if the evidence is clear that our client did kill the person, but say our client suffers from a mental defect, such that he didn't really appreciate the wrongfulness of his conduct at the time, then we might be able to argue that it was not guilty by reason of insanity. And if the jury agrees with us, then ultimately our client would be sent for treatment to a clinic instead of being sent to prison. The fifth typical defense in a murder case is what we call a reduction of the charge from murder to manslaughter. Now, manslaughter is a lesser offense to murder. And anytime you have a trial, a murder trial, the jury has a discretion to find the person guilty of manslaughter instead of murder. Now, in a situation, again, where it's clear that our client did the killing, there's no question about that, but our client acted in the heat of passion or as part of a sudden quarrel, a lot of times we can convince the jury, look, what happened here was not murder, it was manslaughter. And the benefit to manslaughter is that it can entail as little as 3 years in state prison. So someone convicted of murder is going to look at probably 25 to life or more. But if they're convicted of the lesser offense of manslaughter, they could potentially be sentenced to as little as 3 years. And though they don't want to go to prison at all, 3 years is a lot better than 25 to life. So between these various avenues of defense, we've been able to get many murder charges either reduced to manslaughter or outright dismissed, and to spare our client the horrible consequence of life in prison.